Continue to support the delivery of criminal justice in Anambra State and in all the states where ROLAC work. This is particularly a very key area for us because it is an area that is impacting on effective and efficient criminal justice delivery, reducing the docket of the courts, to impact positively on ATPs. By ATPs, it includes women, it includes children, it includes persons with disability. But this is quite novel because this area is not too common. But thank goodness that we'll have it now in our criminal justice law, at least our law in Anambra State, and then the laws of the sister jurisdictions where we borrowed this area of reform. So I would want to start by saying that the area of work that has brought us here today is the component one area of the ROLAC work, which focuses on enhancing performance, quality, and oversight of the criminal justice system. We call it the component one area of our work, which focuses on enhancing everything possible, to deliver criminal justice delivery and criminal justice law, and then deliver it to the letter. So we are saying that beyond enhancing the performance of this criminal justice system, we are as well looking at the issue of diversion and non-custodial measures, as well as rehabilitation and reintegration mechanisms for inmates, including women, juvenile, and persons with disability. Under our ROLAC 1 program, the ROLAC program supported the enactment of the Nigerian Correctional Services Act 2019. And we focus on the area of non-custodial measures. We did quite some work there, ranging from restorative justice, the non-custodial processes and mechanisms. We looked at non-custodial measure in its entirety, and then increasing the capacity of state actors to understand this and then implement that. In Anambra State, we introduced the non-custodial measure. We had a town hall meeting with the prior executive director, Dr. Uju Agombo, who came to talk to us and then took us through, introducing to us non-custodial measure and the best way of implementing it. But it just ended at that. And that last year, I could say that the ROLAC program was able to assess data to the tune of 9, and then that 9 data we got was on cases of community service. We could say it is quite abysmal, but of course Rome wasn't built in a day, and then the journey of 1,000 miles starts with the first step. So for us, that's 9 cases that we got meant so much. And then I am sure that as time goes on, we will increase, and then there will be a higher uptake of this reform area. That is exactly what we have come to talk about today. That non-custodial measure includes restorative justice. All of them are aiming at reducing dockets of cases in the courts, and then aims at impacting positively on ATPs, awaiting trial precedents. So we have come to further entrench docket and prison decongestion measures. ROLAC aims to deepen the interventions that we have done in the past and then expand the use of non-custodial sentences, including probation and suspended sentences for offenders. like we have talked about it, I will say that this meeting today will focus on achieving 3 objectives. And those 3 objectives will be: 1, to further entrench docket and prison decongestion measures, and to deepen the interventions that we have done in the past, expand the use of non-custodial sentences, including probation, suspended sentences, strengthen rehabilitation and reintegration measures and restorative justice, and implement diversion mechanisms for offenders. The second objective is seeking to promote deeper understanding of local context of restorative justice, non-custodial measures, and then others that I have mentioned. Sentencing and diversion mechanism is something that is key to us too, to utilize the opportunity, that exists for us to introduce this and entrench it in a criminal justice delivery in Anambra State. I think the third objective will be to engender wider use of this mechanism in the dispensation of criminal justice, because we are looking at one overarching goal, and then that overarching goal is effective and efficient implementation of criminal justice delivery. We have so many other novel reforms, so many other novel initiatives which is aimed at this. But for this particular exercise, which is aiming at enhancing the use of the non-custodial measure, that is what we have come to talk about. We commenced this in Edo and Lagos State. I don't know if Caroline Etwick is here now. She was a consultant that drove the mechanism in Edo and Lagos State. Like I said, we introduced it partially in Anambra State as well, but it has not really taken root. So we are hopeful that after this meeting, everybody will be brought on board, and then we will continue to try our bit in looking at issues of non-custodial measures. Let us not go through the formal system. We shouldn't be bent at that. We should try the other alternatives. The community service, they work as much. They do. And oftentimes you will find out that they are less expensive, they are less cumbersome, they are low in everything. And at the end of the day, we'll get robust results from all this. That is why ROLAC is thinking that we should go the other way. Since our legal framework has it now, the Anambra State Criminal Justice Law 2022 has it. I remember the ROLAC program reviewed this law years back, and the chairman then, Justice Peace Obiora, made sure that a lot of legislation were looked at from other sister jurisdictions to see the most effective reforms, to see the most beautiful provisions that could cure some of the mischiefs that we suffer in our criminal justice delivery in Anambra State. And to that extent, I will say that I think now we'll have a local content in terms of delivering non-custodial measures. And then we want everybody to live up to it. Let's see the best that we can make out of it. And before you know it, we can be counting our data in numbers. That is what we are looking forward to. So we want to thank the judiciary, we want to thank the Ministry of Justice, we want to thank the justice subsector in Anambra State for giving us this enabling environment to try. If the CJ hadn't welcomed us, if the Attorney General hadn't welcomed us, we wouldn't have been able to achieve today's meeting. And by the way, by introduction, the Nigerian Prison Fellowship, headed by the director here, I find it difficult to pronounce your name, I'm sorry about it.
Jacob Sani.
Okay, so it's ROLAC's grantee. ROLAC cannot be everywhere. Much as we want to implement all these initiatives, but then there are times that we walk through intermediaries. And we have recognized them as an organization that has the capacity and the capability to deliver this area of work. And that's why the rural program engaged them to implement the restorative justice mechanism procedure in Anambra State. They are equally using other key, very key resource persons, like I mentioned, Caroline Eto, who is able and well able to deliver issues around non-custodial measure. Call her up anytime, anywhere. She had come to this state to do an assessment. And after the assessment, her recommendations is in tandem with what we are doing today and with the provisions and the conditions that would have engaged the Nigerian Prison Fellowship with. On that note, I think I want to thank everybody again and then welcome you to this event. And with your support, I think we can achieve so many things. Thank you so much.
The fact is given to you pre-evaluation. It's just to help us to make evaluation. May I call on Honorable Justice O.M. the Executive Director, Dr.
The Chief Judge of Anambra State. Permit me, before I continue my address, to introduce my predecessor in office, who conceptualized the project we are undertaking today. I'd like to recognize Barrister Benson Iwabu. He's one of our resource persons. It is my singular honor and privilege to welcome our esteemed participants to this restorative justice sensitization workshop. Your presence here today reflects a shared commitment to advancing justice systems that are not only fair, but also transformative and inclusive. Our justice systems, while vital in maintaining order, often find themselves burdened with cases where traditional punitive approaches do not lead to meaningful solutions. This is especially true in situations involving vulnerable populations such as juveniles or first-time offenders. Restorative justice offers us an alternative, a path that prioritizes healing, accountability, and the restoration of relationships over retribution. This workshop is being held under the Prison Fellowship Nigeria Restorative Justice Rehabilitation and Reintegration Project, which is designed to integrate restorative justice principles into the justice system, offering practical solutions to challenges such as overcrowded courts, high recidivism rates, and the social stigma faced by ex-offenders. As the ROLAC representative has informed you, the PF Nigeria Restorative Justice Rehabilitation and Reintegration Project is being implemented under the Rule of Law and Anti-Corruption ROLAC 2 program, funded by the European Union and managed by the International Institute for Democracy and Electoral Assistance, International IDEA. This initiative aims to strengthen the rule of law and enhance anti-corruption reforms across Nigeria. This project spans 8 states, and the states include Adamawa, Edo, Abuja, the federal capital, Plateau, Abia, Lagos, Kano, and of course, Anambra State. This workshop, this sensitization workshop, is the 4th in a series of sensitization events we plan to host across these 8 states. And the theme is fostering justice, reconciliation, and community healing. Now, Why is this sensitization workshop important? I just want to reiterate that the success of restorative justice requires the support and active involvement of key stakeholders, such as yourselves gathered here today. That is why we're excited to see this diverse array of participants from the broad spectrum of society, including the judiciary, Ministry of Justice, law enforcement, correctional services, traditional and religious leaders, the youth, women, media, and other members of the community. Restorative justice is an inclusive approach that emphasizes repairing the harm caused by criminal behavior. It seeks to address the needs of all parties involved. For offenders, it focuses on their reformation, rehabilitation, and reintegration into society. For victims, it provides validation, healing, and reparation. And for the society, it aims to restore social harmony and peace, which are fundamental goals of justice. This approach fosters accountability and active participation from offenders, encouraging them to understand the impact of their actions and to make amends. It also empowers victims by giving them a voice in the justice process and addressing their specific needs. By involving the community, restorative justice promotes healing and the rebuilding of trust, leading to a more cohesive and just society. Restorative justice offers a victim-centered approach to addressing harm, emphasizing accountability, healing, and reintegration. As a diversionary measure, restorative justice provides a viable alternative to incarceration, addressing systemic challenges such as overcrowded correctional facilities and high recidivism rates. Criminal justice practice in Nigeria, as you would agree, has mainly focused on retributive justice with an emphasis on punishing offenders for their crimes. Restorative justice shifts this approach and instead focuses on restitution, restoration, and reintegration. Diversion is meant to give offenders a second chance in life, assisting them to reintegrate into the community and reduce the risk of reoffending. Diversion also ensures that individuals avoid a criminal record, but nonetheless atone for their mistakes. In this respect, the project that we are embarking on is focused on these vital areas. One, restorative justice sensitization. We hope through restorative justice sensitization workshops such as we are having today, to raise awareness and encourage the adoption of restorative justice as an alternative to traditional punitive approaches in the criminal justice system. Then capacity building. We plan to conduct training sessions for stakeholders, including legal practitioners, law enforcement agencies, social workers, and community leaders on the principles and practice of restorative justice. Then establishment of restorative justice centers. We will support the creation of restorative justice centers within designated courts to facilitate pre-diversion programs and alternative dispute resolution mechanisms. And lastly, rehabilitation and reintegration support. This project further aims to empower ex-offenders through skills development and community reintegration initiatives. What are the objectives of this workshop? Josephine earlier alluded to this, but if I might reiterate, is to create awareness about restorative justice principles, benefits, and applications, to highlight the roles of stakeholders in implementing restorative justice, to foster collaboration among key stakeholders for effective adoption and practice, and lastly, to address challenges and identify solutions for integrating restorative justice into the legal framework. Before I end this address, permit me to give you a little brief on our organization, Prison Fellowship Nigeria. Prison Fellowship Nigeria is a non-governmental organization committed to transforming the lives of inmates, ex-inmates, and their families through restorative justice, criminal justice advocacy, and rehabilitation programs. Its work aligns with global best practices in promoting justice that heals and restores relationships. Prison Fellowship Nigeria is a chartered affiliate of Prison Fellowship International, which has chapters in over 120 countries. Prison Fellowship Nigeria also holds observer status with the African Union Commission on Human and People's Rights. The fellowship collaborates with over 1,000 volunteers serving in more than 80 of the 240 correctional facilities across 31 states and Abuja in Nigeria. Prison Fellowship Nigeria focuses on the reformation, rehabilitation, reintegration, and welfare of those who are incarcerated and those impacted by crime, utilizing spiritual, psychological, social, educational, and personal development programs. PF Nigeria provides specialized training for volunteers and prison outreach workers, offering programs and projects for the rehabilitation and reintegration of individuals affected by crime. We offer guidance on restorative justice and ethical principles to criminal justice administration and correctional officers, all in furtherance of the reformation, rehabilitation, and reintegration of inmates. We can't repeat that enough. I would like to express my heartfelt appreciation to the Honorable Chief Judge of Anambra State, here represented ably by Justice S.N. Okoye, for his support and endorsement of this laudable initiative and for his forward-looking perspective on justice delivery in Anambra State. We appreciate the active participation of the judiciary in this endeavor. I wish to pay special appreciation to the Attorney General and Commissioner of Justice of Anambra State, Professor Sylvia Chika Ifemeje, also represented, for her compassionate approach to justice. Her gracious approval to hold this workshop in collaboration with the Office of the Attorney General is a testament to her unwavering commitment to judicial transformation and advancing justice in Anambra State. We are also profoundly grateful to all the other stakeholders who are present in this workshop. Let me thank once more the International IDEA for supporting Prison Fellowship to implement this project and for the confidence you have reposed in us. I want to say that we look forward to our credible resource persons who are present here.
Presents the Honorable Attorney General of Anambra State to deliver her keynote address. She had desired to be here, but she has a matter at the Court of Appeal, so that's why I'm here to deliver the keynote address. Keynote address delivered by the Honorable Attorney General and Commissioner for Justice, Anambra State, on the topic, the transformative power of restorative justice, at the high-level stakeholders workshop organized by Prison Fellowship Nigeria. Introduction: the need for a paradigm shift in justice. It is with immense pleasure and a profound sense of duty that I stand before you today at this high-level stakeholders workshop organized by Prison Fellowship Nigeria, an organization that has continued to champion the cause of restorative justice in Nigeria. This gathering marks an important step in our collective efforts to reimagine justice, not merely as punitive, but as a vehicle for healing, reconciliation, and societal transformation. For decades, the criminal justice system in many jurisdictions, including Nigeria, has predominantly operated under a retributive model, where crime is seen as an offense against the state, rather than an injury to individuals and communities. While this model has served a function, it has often failed to address the root causes of crime, promote rehabilitation, or foster true reconciliation between victims and offenders. Restorative justice, on the other hand, seeks to change this narrative by shifting the focus from mere punishment to accountability, healing, and reintegration. It is an approach that acknowledges the harm caused by crime and provides an inclusive process through which offenders take responsibility, victims find closure, and communities regain trust and social cohesion. Restorative justice is built on three fundamental principles. 1. Repairing harm. Crime does not just violate the law, it disrupts lives. Restorative justice seeks to heal these wounds by ensuring that offenders take meaningful steps to make amends. 2. Inclusive participation. Unlike the traditional justice system that sidelines victims, restorative justice actively involves victims, offenders, and the community in the resolution process. 3. Reintegration. Punitive measures alone often lead to stigmatization and recidivism. Restorative justice provides a pathway for offenders to reintegrate as responsible members of society, reducing the circle of crime and incarceration. The transformative power of restorative justice. The impact of restorative justice is far-reaching and transformative in multiple ways. First, for the victims, it provides an avenue for healing, emotional closure, and empowerment. Victims get to voice their pain, seek answers, and in some cases, even forgive. Second, for offenders, it fosters accountability and personal transformation. Offenders who engage in restorative justice processes are less likely to reoffend, as they gain a deeper understanding of the consequences of their actions. Third, for the criminal justice system, by offering alternative dispute resolution mechanisms, restorative justice helps recongest our courts and correctional facilities, allowing the justice system to focus on more severe crimes. 4. For society, a society that embraces restorative justice fosters a culture of dialogue, peace, and reconciliation, leading to safer and more cohesive communities. Restorative justice in Nigeria. The legal and institutional framework. Nigeria's criminal justice administration historically relied on the criminal code in the south and the penal code in the north, both of which are largely retributive. However, significant strides have been made towards integrating restorative justice into our legal framework. The Administration of Criminal Justice Act and laws, ACJL, have introduced radical changes, incorporating restorative justice mechanisms such as plea bargaining, suspended sentences, community service, probation, and rehabilitation. Similarly, the Violence Against Persons Prohibition Act and the Child Rights Act provide avenues for non-custodial sentencing and victim-centered justice approaches. In Anambra State, the ACJL 2022 enshrines restorative justice provisions in chapters 27 to 29, covering costs, compensation, damages, probation, and plea bargaining, section 167. Despite these progressive laws, application has been minimal due to factors such as 1. Lack of awareness and understanding of the provisions. 2. Reluctance by magistrates and judges to adopt restorative justice approaches. 3. Absence of necessary practice directions and guidelines for implementation. Ongoing efforts in Anambra State. Here in Anambra State, we are committed to strengthening these initiatives. As Attorney General, I am pleased to highlight some of the ongoing efforts. First, restorative justice pilot programs, collaborations with NGOs and civil society organizations, including Prison Fellowship Nigeria, to implement mediation and reconciliation programs. Second, diversion programs for juveniles, ensuring young offenders are given opportunities for rehabilitation rather than incarceration. 3. Training for law enforcement and judicial officers, equipping key stakeholders with the knowledge and skills necessary to implement restorative justice effectively. Challenges and the way forward. While the benefits of restorative justice are undeniable, its implementation is not without challenges. These include 1. Public perception. Many still view justice strictly through the lens of punishment. Advocacy and awareness campaigns are necessary to change this mindset. 2. Capacity building. Law enforcement, judicial officers, and community leaders need continuous training on restorative justice practices. 3. Legislative gaps. More robust legal frameworks and policies are needed to institutionalize restorative justice at all levels. To overcome these challenges, a multi-stakeholder approach is required. Government, civil society, legal practitioners, and community leaders must work together to create a justice system that truly serves the people. Conclusion. The transformative power of restorative justice lies in its ability to move beyond retribution towards healing and reconciliation. Provides a justice model that is not only fair, but also humane and forward-looking. I commend Prison Fellowship Nigeria and its international partners for their unwavering commitment to promoting restorative justice. As a government, we pledge our support to initiatives that align with this vision and will continue to explore policies and programs that integrate restorative justice into the fabric of our legal system. Together, let us build a justice system that restores, rehabilitates, and reconciles. The time for this transformative change is now. Thank you, and may this workshop yield meaningful outcomes that will benefit Anambra State and Nigeria as a whole. Professor Sylvia Ifemeje, Attorney General and Commissioner for Justice, Anambra State.
Thank you, Barrister Nneka.
Once more, I am a woman CSP, Chief Superintendent of Police, Florence Ayogo. On behalf of CP Anambra State, I appreciate the effort and I commend Prison Fellowship of Nigeria for your commitment to have created this transformation via restorative justice. As you all know, our power is restricted to arrest, investigation, and prosecution. And I thank God that it is no longer business as usual, where they say prison. It is no longer prison, but correction center. And when we prosecute, our happiness and joy is that you used to reconcile them, correct them, and do the needful before they are out of the prison. I am saying that we will continue to be prosecuting whoever we found guilty of any offense for the restorative to be carried on. Thank you very much. Thank you very much.
Please, you
please, it is not a recognized projector right now.
Correctional service, as we all know, has been more than an active member of Anambra criminal justice in the growth of Anambra criminal justice practice of success story. We have been doing a whole lot with regards to reformation, rehabilitation, and reintegration of inmates. And also the new ideas, concepts of probation, restorative justice, plea bargain, and the rest. So Roland and the rest of us here are witnesses to that fact. So we continue in that same vein to lend our weight behind seeing to it that the share of criminal justice law of Anambra State is seen to be operational, fully operational in the state, and with resounding success stories. We believe we have a whole lot of success stories coming out from our end and other stakeholders as well. So the issue of restorative justice is a welcomed concept whereby the state, the victim, and the offender are all interfaced or brought in to address the teething problems of justice sector or criminality in the state, with a view to solving it in a rather win-win situation. Just like under arbitration, we have conciliation, mediation, and all that. This restorative justice helps a lot to bring closure to the victim. You know, before now, victims are not normally brought in. The state will just prosecute somebody, jail the person. What happens to if it's in law, we say the rest is never brought back together. The rest is either permanently eroded or destroyed. So, but restorative justice makes a very good attempt to bring about healing or redress to the victim. Whereas the offender himself gains on his own part by having some element of accountability. Here he comes and owns up to his crime, shows his remorse, and is willing to make amends through our internal reformatory mechanisms we have in place. And we're there to vet it to see that actually he is being truly reformed. Just like people we send for amnesty. You know, inmates apply for amnesty. You don't just apply that you wish for amnesty. You get report from us confirming that you are truly a reformed person. Some other NGOs or stakeholders that have been partnering with us in that reform program will also testify to your conduct before we now move on to other things. So it's a very welcome development, very, very welcome development. And I believe we are here today to further embellish that fact. So thank you.
Protocol has already established, permit me to, before the independence of Nigeria, it has been to punish the offender. But this time around,
restorative justice principles.
Good morning, everybody. I'm the director of the Enugu State Multi-Law Courthouse. I have a legal background and I have been in the field of alternative dispute resolution for maybe near 20 years. 2018, how many years is that from now? 7 years. Okay, so like maybe most of you here, I'm still within the learning curve, which of course in life never ends. You just keep going and keep on learning. So today, my main responsibility this morning is to give you an introduction of restorative justice. And the whole idea behind this workshop is that at the end of the day, we would all have some measure of understanding of restorative justice, number one, and secondly, kind of a heart acceptance of the concept. I've had the privilege of doing some scoping study to find out around at least 4 states in the country, Anambra inclusive, Adamawa, Kano, and the FCT. My mission on that Rolec 1 was to find out from different sectors of society how acceptable is restorative justice. Like my Lord has said, it's not something that is even familiar to the judiciary or to the legal profession. So, 2019, the Correctional Service Act was promulgated, and it has moved justice reform in an entirely different direction. So, we're not going to abandon criminal justice administration as we have known it, but restorative justice, which is a transformative arm of criminal justice is going to be layered upon that foundation. Okay? So are we all ready to hit the ground running? And are responsible for his or her actions by providing an opportunity for the parties directly affected by crime, which usually are the victim, the offender, and the community. That gives an opportunity to identify and address what their needs are coming from the aftermath of the crime. Now, has anybody lost a phone before? Please, just tell me if you've lost the phone. Raise your hand up now. Okay, those of you that haven't lost the phone, you're blessed. You lose a phone, you think, it's just a small device. But in that device, you have a lot of valuable information. In fact, that device, even in a manner of speaking, is a friend. Okay? Because even on down days, if you open some of those platforms, you will laugh yourself to stupor. So, in a manner of speaking, it is also your connection to your loved ones. It's a connection to the whole world. So if you lose a phone, as small as it seems, you know you've actually lost something. So there's a loss to the victim, to the offender, and to the community. So restorative justice gives an opportunity where everyone comes together to do what? To address the harm that has been caused and to find means of making good this harm. So that basically is the definition of restorative justice. And as we go on, you're going to find that a lot of the concepts, a lot of the core principles are going to be recreated over and over and over again. It's not, I would say it's a wide, unwieldy, robust field, like you'd say the law is, or criminal justice, traditionally speaking. But restorative justice is something that intrinsically has to have a foothold on your heart, on the better part of you as a human being. Now, the history of restorative justice, many of us know that in traditional societies from time, disputes are resolved. Now, we had a validation workshop in Anambra State years ago, still on restorative justice, and we had some traditional rulers of standing. And I was interestingly surprised that one of the traditional rulers actually mentioned that even in murder cases, in some communities in Anambra State, resolutions are reached. Is that correct or not? Yes. Resolutions are reached, and that the matters never get to the police. I also had that information created by some interviews at the Ministry of Justice, where State Council said, we have murder cases that we have been doing for years and years and years. And you know what? The victim, which is now, of course, because the deceased person is dead, but family of the deceased, people that are directly affected by that hurt, and the community, and the offender, who is in custody, of course, the offender's community, they get together, and this is when the justice system is even involved. They go and they settle. When they settle, they come to the court and they come to the prosecutor and say, we don't want this case to go on. And prosecutor says, why don't you want it? State against Okafor. It's state against Okafor. So they said to the prosecutor, is it state against Okafor? And you know what? They said, we're not available as witnesses. We have been locking up our shops for the past 5 years, coming to court, up and down, up and down. Nothing is happening here. So, you know what? We're not available to witness. So what happens next? Prosecutor cannot move. My Lord, am I lying? No. So when the prosecutor cannot move forward, what happens? You strike the case out. You strike the case out. So that interface between victim, offender, and community, that is what restorative justice makes possible in a formal setting, in a formal forum. Now, rather than it being, I've also heard some really bad stories about communities, traditional communities trying to settle disputes, and it just did not go well. Because at the end of the day, community will say, what's the matter with you this man? We have said that these people should pay you so and so, and you refuse. So you're on your own. And the victim does not get, just like it happens under the justice system, the victim does not have any redress. Okay? So that is for us in Nigeria. But what we are going to talk about now primarily has to do with a restorative justice system that we have adopted, just like we adopted the British colonial justice system. So, how did these ones begin? There are 3 types we are going to discuss this morning. There's a victim, offender, there's a circles, and there's a conference. Now, for this victim-offender mediation, how did it even start? It says it started in Ontario in the 1970s. And just a situation happened where 2 children, youth, they vandalized somebody's property. And the probation officer, they were already convicted, the probation officer thought, okay, what can these young people, what's really the point? The person who was hurt the hurt has not been addressed, and convinced the judge, let these people meet and talk. Perhaps there can be solutions. And that was exactly what happened. They met, they talked, the victim and the offender had a meeting, and the matter was resolved. The resolution was that these 2 youths were ordered to pay a restitution to the victim. Now, that was the beginning of the victim-offender mediation. And from the 1970s, it has grown to date. Please let me know how much time I have, sir. That started off maybe about the 1980s. And from the Yokan community, now these people had a way of dealing with their youths. When children were in trouble, they would not take them out to the justice system, but within the community. The community sat along and they pronounced a sentence as to how the child or how the youth, the young person, was to be dealt with. So dealing with young people was kind of a community type of thing. And they sat in a circle and they would usually address those issues. Okay? Now, the conferencing too was something that originated in New Zealand, And these are like concepts that sprung up from traditional practices. Just like we have traditional practices in Nigeria, okay, and in Africa. Now, some other concepts that have sprung up, restorative justice concepts, are like the peace and reconciliation programs in South Africa after apartheid, and like the Gacaca courts in Rwanda. Those are things that have had original from the roots, from the very origin, indigenous persons, practices. Now, what are the fundamental principles of restorative justice? Crime causes hurt, and justice should focus on repairing harm. It's only common sense. Justice should focus on repairing harm. The people most affected by the crime also should participate. Okay? It shouldn't be a matter between the state and the state and the offender, and everybody else is a spectator. Now, victims need an opportunity to confront their offenders directly. Does that happen normally? Is the question I want to ask, does it ever happen? That's in the proper courts? No, it doesn't happen. Okay, so in restorative justice, victims have the opportunities to confront the offender directly. If somebody stole your car, would you want to confront the person directly?
Yes, I will.
Why would you want to do that?
As a person, not working as a judge, but as a person to deal with the person.
Say in the response to crime, to the crimes they have suffered, and they should have the opportunity to generate options for the offender to make amends. What it simply means is that when I'm seated at that table with the offender, okay, I want an opportunity for me to ask the offender, you took my phone, please, why? Where is the phone? When your phone gets lost, who doesn't want to know where the phone is? Pardon? It's the first question. Where is my phone? When can I have my phone back? Did you remove the SIM card? Where is the SIM card? Did you delete all my contacts? Did you try to hack my bank account? Now, if an offender makes amends, he or she should be reintegrated into the society. A fair thing to say. Is that a fair thing to say? Okay, what does it depend on, my Lord?
That are meant.
Yes.
And it's really not to repeat such.
Okay.
Reintegration into society is an opportunity to make him a part of that society where he lives and be a better person. And even an example.
Okay.
An example for others to see.
Okay.
Yes.
Encountering the other side, like we said, face to face. All right? One-on-one, and speak with the help of the facilitators. Reparation means making amends to repair the harm done by the crime in any way agreed by the parties in the course of an encounter. Reintegration of the parties into their communities. Restorative justice places a high value on reintegration. That's the entry of a person into community life, which is what you have mentioned. Now, active accountability.
That's why you're here.